Welcome to Deals and Disputes with the West Webb Law Group.
Hello and welcome back to Deals and Disputes with West Webb, Albritton, and Gentry. Today's guests are Jay Rudinger, a partner at the firm who specializes in business disputes, employment disputes, and more, as well as Terrance Dill, senior counsel with more than 3 decades of experience in civil litigation, mediation, and arbitration. My name is Kevin Rosenquist, and today we're breaking down a topic that shows up in more contracts than people realize, and that's arbitration clauses. Gentlemen, welcome.
Hello. Thanks for having us.
Open to anyone who wants to answer. What exactly is an arbitration clause? Let's get that out of the way so we can continue the conversation.
An arbitration clause is something that you really kind of have to look at when you're doing any deals on the transactional side or putting anything together, even employment-wise, because it gives you opportunities and options, should you have a business divorce or something come up in the long run. Our job is to always think of the worst case scenario. So while we're making a deal, we're already thinking about what's going to happen at the end if things don't work out great. And that's where you really want to think about an arbitration clause to consider it. And there's pros, there's cons to each side while you're thinking through it. But it's something that you definitely want to consider whenever you're putting together an agreement as to how you might have to handle this once everything shakes itself out at the end.
So, Kevin, basically an arbitration clause is any clause in the contract that would state that the parties to the contract would have to take any disputes that they have to arbitration as opposed to going to court. So it can be an important provision of any contract. And when you're having one contract drafted, or when you're looking at one as to whether or not you want to get involved in the deal via the contract, then you need to get advice from your counsel as to whether or not the arbitration clause is something in your best interest.
Okay. Yeah, and no one goes into a business deal thinking, oh, this is going to go sideways fast. It's like a marriage, right? Like no one goes into a marriage thinking it's going to end, but we do have divorce attorneys. So these are obviously very important clauses to have. The
common denominator there would be the attorneys. Your attorneys, of course.
Oh, that's true. That's true. You said it, not me. So the purposes for the arbitration clauses in the contracts are basically to just kind of set out what happens if there's an issue. Correct? I have that correct?
Yeah. What it does, it selects kind of the venue for where you're going to go have your issue resolved. So if you have in most instances, you have a fallout, either employment side or between businesses or something in that regard, everybody thinks you're running to the courthouse and you're going to go in front of a judge and you're going to have a long drawn out process and finally get some resolution. Arbitration gets you that resolution generally quicker, can be close to more expensive, less expensive. Again, depends on how you handle it, but it's just lets you pick where you're going to have it resolved. And with each side comes some pros and cons.
And it's basically, so that's the difference between going to court. It's less expensive. It's less drawn out. It's a little more, I don't know, just a shorter process. Is that kind of how it works?
It generally will be a shorter process just because there's certain rules, either the Texas rules, federal rules, there's third-party rules, and they're pretty cut and dry. There's a lot less time involved. There's other things you look at, confidentiality in arbitration. If you file a lawsuit, anybody and their brother can come down there and read the dirty laundry that you're filing in the court. Arbitration is going to be kept confidential just between the parties, as well as then enforceability at the end. A verdict in a trial court can go up on appeal 1, 2, 3 different stages before you get any resolution, and it might come back to a trial court. There's a lot of up and down. For arbitration, for the most part, with some exceptions, what the arbitrator says goes at the end of the day. So there's speed in getting it done. There's costs. It's expensive for an arbitration, but you're paying for the speed and the time you have on it. You have a judge that frankly has subject matter expertise in what you're doing. And then you have the confidentiality side and the finality side. So you can be in and out of an arbitration in terms of months, where going through a court and going through all that process, you're talking years in plural.
You mentioned, I think you mentioned employment and business agreements and stuff. Are there other places where arbitration clauses are fairly common?
Probably the most frequently type of contract that you see an arbitration clause is in a construction contract. And then, of course, in certain consumer contracts have arbitration clauses too. So If you've got a big construction project going on, then any disputes between the landowner, the general contractor, and the subs are almost always governed by an arbitration clause. And then there are certain consumer transactions or deals. The biggest one is FINRA is a organization that handles disputes between people who buy shares or stocks in a company and the stock broker. And so those are all governed by a clause in the contract that you'd have with your stockbroker and would have to be resolved under the FINRA rules or guidelines.
Okay. And when you guys draft a contract with a client, what are the kind of things that you consider maybe before adding an arbitration clause, or maybe you're as you're drafting the arbitration clause, what are the considerations that you push for or you talk about with your clients?
I think one of the things you kind of got to look at is, as we mentioned earlier, as attorneys, we're looking at the worst case scenario. So you try to figure out at the end of the day, if things don't go great, what's it going to look like? What are we going to be fighting about? What are we going to be fighting over? Because generally that's going to determine if arbitration is the right decision or the right call. If we're going to be fighting over smaller amounts of money, if you're talking a case that might go to justice court for $20,000 or less, you're going to run $20,000 in arbitration costs quickly and paying your arbitrator, who's a specialized judge in that instance. So there, it's better to go to the courthouse and try to get whatever relief you can get and look at it that way. One other thing we always look at is, are we going to need any immediate relief? Is there going to be injunctive relief that might be required when we're drafting a clause? Because in a lot of instances, we'll put something in there that says if a party needs to go get injunctive relief or a temporary restraining order to stop somebody from doing something, you can go to the court for that. Once that's been resolved, then we go to arbitration. But if you don't think about that on the front end, you file for arbitration, there's time for an answer, then you got to pick an arbitrator, and you're talking 30, 60, 90 days down the road before you have anybody you can talk to about, hey, we need to stop this group or this party from doing something before you get that opportunity for that relief. So there are some things you want to look at that say, hey, maybe this isn't going to be the right disputes that you want to go to arbitration on, just as to the total amount due, or we might need to run down to a courthouse and get some immediate relief before we run into arbitration. Those are the kind of things you want to consider before you go and just plunk an arbitration clause into a contract to move down the road, or don't put one in there.
And similarly, if you're a party that's wanting to enter into a contract that already exists, and you'd want your lawyers to advise you on whether or not you should enter into this deal that's put in writing under the contract with an arbitration clause. Is this going to be more efficient for you if you have a dispute? Is it going to be fair for you? Are there going to be one arbitrator, or are there going to be a panel of three? Usually, the more the arbitrators, the more expensive it'll be. Mm-hmm. And so, obviously, you wouldn't want to have agreed on a 3-panel set of arbitrators for Jay's example of a $10,000 suit that could be handled in justice court, right? On the other hand, if you had a $10 million dispute involving some highly specialized area of dealings, then you might want to have 3 arbitrators that have experience in that subject matter, so you could be assured that you probably get a fair shot at the whole decision-making process.
Are there other risks or downsides to the arbitration clause that people should be aware of before they even sit down and start talking about it with their attorney?
There are some cons. The biggest one that usually comes into play is you're paying for a judge. When you go to court, your judge is paid by your taxpayer dollars, so you're not having to pay the judge to spend time on your matter, spend time focusing or learning or researching about any of the law that's involved there. You're in front of the judge gets to make any determination. So from a $10,000 to a $10 million dispute, those judges are you're not cutting a check to the county you're in or the judge that's sitting on the bench. Whereas in arbitration, you're paying an hourly rate for your arbitrator. You're paying them time to read through the pleadings. You're paying them time to sit as the arbitrator on your matter. So you can run into a very expensive proposition quickly. But with that, again, comes confidentiality, finality, and those types of things. So that's why you see this generally. Arbitration clauses are going to be found more in complex relationships, complex disputes, where we want to make sure we get it done correctly. We want somebody who's specialized in that area if possible. And we want to make sure we get the best resolution we can and make sure we get the right answer rather than a judge who's trying to call balls and strikes on one of 1,000 different cases in front of them and then heading up on appeal. And the hearing before it, they talked to somebody about a dog bite, and now they're trying to hear your $5 million business dispute and give it the same amount of effort and time.
That's interesting. Yeah, I didn't think about it like that, bouncing back and forth between different types of cases. Yeah, it could be interesting for sure. How enforceable are these clauses? Do courts ever strike them down?
Generally, the courts are very in favor of arbitration clauses, and that's almost uniform between the federal courts and all the state courts. So and that course of jurisprudence has been going on for probably 30 years. As arbitrations have become more and more prevalent, the courts seem to like them. So, in fact, I think it'd be a struggle to find a case that the court didn't like the parties going to arbitration.
Yeah, the courts get two benefits out of it. One, they don't have to hear it. So they get to take one case off of their docket and send it off to an arbitrator. So for them, that's they get to check off one thing on their to-do list for the day and move on to the next. The other thing is an arbitration clause is going to be found in some agreement between the parties. And if you agreed to it, we're going to make you, you made the bed, you got to lay in it now. So we're going to make you stick to your agreement unless there's some reason not to. Somebody lied to you, it was unconscionable, you didn't have any bargaining power. There are some exceptions, but you got to show a whole lot of ill will and ill treatment from the other side. I mean, there's case law out there where it was tucked in the back of an employee handbook that was in English when the employee only spoke Spanish, and they said, that's close enough. You should have read through it, and if you didn't read through it, you should have found somebody that could, and we're going to go ahead and enforce this arbitration provision. So it is tough to find where courts haven't enforced it. There are a few cases out there, but it has to be some pretty egregious conduct.
Kevin, there's also cases where courts have found in some instances that people that weren't even a party to the contract had to go to the arbitration process because of their involvement with other parties that were involved in the contract. Mm-hmm. That's not uniform, but it has happened. So you could be going to arbitration on a contract that you didn't even sign.
That's okay. That's a good point. Yeah. In your experience, do the arbitration clauses generally help these cases go more smoothly?
I'll leave it to the arbitrator to make the.
Yeah, I it's a good process if everything goes according to the plan. There's two large entities in the United States that or I guess you could call them arbitration companies, for want of a better word, that have a very structured system. So usually the contract will reference, hey, this is going to be resolved pursuant to, and then they'll name one of the companies. And then these companies have their own sort of rules and such. And once you get in, they'll assign a case manager to the matter, the dispute. And then there's an arbitration selection process where usually you look at a roster of potential arbitrators, and the parties agree on one, and then the arbitrator gets assigned and make sure he doesn't have or she does not have a conflict, and then you then proceed, and usually they're resolved in a matter of weeks or months.
The thing you like about arbitration clauses is there's some certainty there that you don't necessarily get to experience in a courtroom, where knowing who the judge is or what the judge's expertise is or the time that the judge is able to devote to your matter, you're kind of rolling the dice when you go into those different arenas, especially counties with multiple judges and multiple courts where you're getting randomly assigned to a court once you make your filing. So what it provides is it provides some certainty and uniformity. If you've done one arbitration, you've probably done, the next one's going to go 80 to 90% very similarly. Now there might be some differences in selecting arbitrators, or one versus three, or a panel of that. But for the most part, the process is going to be very similar case to case in an arbitration. So you get some certainty in how you're going to handle it, as well as a little bit more certainty in who's going to be handling it.
And just for clarity purposes for our show, this is not mediation. Mediation is a different thing than arbitration. That's correct, right?
Yeah, a mediation is basically a fancy word for a formal moderated settlement conference. And the mediator is the moderator. So his job is, he's got parties here and here, and he's trying to get them to a deal. Whereas the arbitrator is more like a judge presiding over a matter without a jury. So the arbitrator hears the evidence, hears the argument, and then makes a decision, generally called an award. And as Jay mentioned earlier, the award's generally final, not subject to appeal. So they're two completely different roles.
And I will say most people like to juxtapose both of those terms, and they think mediation is arbitration and arbitration is mediation, and they don't, or they think they're just the same thing, and we call them by two different names. So it is something you want to make sure, we make sure, and we talk to our clients about it, is this isn't, we're going to sit down and try to work something out, and if we don't, we all go home. This is a final say in determining your dispute, in arbitration at least.
And to make things even more complicated, often in your clause, your dispute resolution clause, there'll be a provision that says, if we have a dispute, we're going to go to mediation. If mediation is unsuccessful, then we're going to go to arbitration.
So you can have both those clauses in there to try one before, because I know in a lot of situations, mediation is preferable, because maybe then you can just sort of, it's, I think, cheaper, right? And you can just sort of lay your terms out a little bit better without having someone make a final judgment. So I can imagine that that's probably preferred in a lot of situations, if possible.
Yeah, it gives you an opportunity to maybe within days or weeks get something resolved. If it's something small, if it's something minute or minor in your grand scheme of things, we can get that resolved and keep moving on. Even a lot of times you'll see the relationship doesn't fall apart. We're having a hang up over how we're going to handle this little thing. We're going to solve that, and we'll move on to the next thing. So in a lot of those instances, you will see those two combined to see if we can get a quick resolution. And if we can't, we're going to have to go ahead and move forward. And then again, with the speed of arbitration, sometimes at the end of the day, we shake hands and we keep doing business together because we were able to resolve something quickly enough and get an answer that, yes, these costs or this is included or not included or whatever we're fighting about. And we can go forward operating under that new premise as to how our relationship will work together. So a lot of times you file a lawsuit, we're done because of the length of time it's going to go. Arbitration, you can get in and get out pretty quickly, which lets you maybe even salvage the overall process, what you're trying to do, whatever your business venture is, and be able to keep doing that at the same time while getting a quick answer on a dispute you have.
And then for anyone listening who might be about to enter into a contract, with whether it's a business contract or, like you said, a construction contract, how important is it to talk to their attorney about arbitration clauses? What advice would you give?
I think the primary advice is call your lawyer.
Yeah.
I mean, it's probably similar to, I'm not going to rewire my house, right? I'm going to call an electrician, because I could get hurt.
So I shouldn't do that?
You should not do that. Call an electrician, because you could get hurt. Call a lawyer, because you could get hurt.
Mm-hmm.
And I think it's a very poignant piece of advice in this day and age where we are cleaning up AI generated contracts daily that people think are going to write as good of a contract or as airtight of a contract as they thought they would get going and talking to a lawyer about it. And then suddenly we have clauses that are open-ended or arbitration clauses that aren't clear as to scope or who's going to have what rules apply or how many arbitrators we're going to have. It says arbitrators, which means more than one, but it doesn't say three. So there's a lot of things that go into a good, not only just a contract in itself, but a good arbitration provision or any claim dispute provision, that you want to have somebody that's been through them, has handled them, has drafted them before, and knows the questions to ask. The worst thing you can do, I think, is cut and paste from your last contract and put that same arbitration provision into the next one, because you really need to tailor it to the people that are involved and the potential disputes you might have involved, because that's going to really dictate to what extent you need to have arbitration, court, mediation, or some combination of the three.
Mm-hmm. And if you're someone that's going to enter into a contract that someone like Jay's already drafted, then you'd want to have your lawyer review that to make sure that the contract's fair from your perspective, or at least something that you want to do knowing all the risks.
Mm-hmm. Yeah, that makes sense. All right, well, that's going to wrap up today's episode of Deals and Disputes with West Webb, Albritton and Gentry. If you'd like to learn more about the attorneys or hear past episodes, visit westwebblaw.com. That's web with 2 B's. Thanks for listening. Be sure to like, leave a review, and subscribe to our channel so you don't miss future episodes. Jay Rudinger, Terrance Dill, thank you both so much.
Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.